I'm Alex Grant, and this is the Law of the Case podcast for May 29th, 2024. Last night, at about 8 p.m., closing statements concluded in Donald Trump's hush money trial. Judge Merchan scheduled jury instructions to begin the next morning. That's how long the closing arguments took. All day, 10 hours between the prosecution and the defense. This episode goes into some top-line observations about closing arguments. The jury instructions, which, as I indicated in my last episode, are so crucial to the outcome of this case, will be addressed in a separate episode once we get them. It seems like the jury instructions have been and continued to be a bit of a mystery. What was filed online were proposed jury instructions where the defense and prosecution each offered their own versions. And it appeared that even as closing arguments were beginning, the judge was still working it out. And he told the lawyers to stay away from talking about the jury instructions, which I would have found a little disconcerting because that's the type of argument a lawyer wants to be able to make. You want to be able to tie your arguments about the facts to the law. And it's very difficult to do that if you don't know exactly what the jury instructions are, especially on the important disputed issues, like the one that I discussed in the last episode of the requirement for proving Donald Trump's criminal state of mind, or in other words, mens rea. The first top-line observation I'll make is just about the order of the closing arguments and how that differs from what I encountered through the trials that I did in the District of Columbia and in Massachusetts. Every trial I ever did had the prosecution going first with their initial closing argument. The defense then followed, which allowed the defense to respond to what the prosecution had said at first. And then the prosecution would get a rebuttal. And that necessarily had to be short. It was not allowed to be very long, and it had to be directly responsive to what the defense had said in their portion of the closing argument. The reason for that was that judges were always very sensitive about allowing one side to be able to make an argument without the other side being able to respond. Now, in the Trump trial, Judge Merchan had a different order. He had the defense go first and then the prosecution go next with no rebuttal for either side. So in that order, the defense actually was probably still wondering exactly what the prosecution was going to say in closing arguments. Now, of course, the two sides have a pretty good idea of what the main themes are, what the main defenses are, what the main theories of prosecution are. Those have been illuminated during the questioning of witnesses, through arguments to the judge, and most importantly, through the opening statements. However, and I can just say this from experience, there's still a lot of decisions to be made, what to emphasize, what to leave behind when you come to closing argument. That's really what a good closing argument does. And not being able to respond, I think, is a significant handicap. The other thing that I thought was a little strange was the amount of time that Judge Merchan was allowing the parties. From what I have read, all the reporting, all the tweets that I saw coming out of the courtroom, it appears that Judge Merchan simply asked each side how long they wanted for closings. Trump's lawyer said that he wanted 2.5, 3 hours. The prosecution said they want 4.5 hours. Judge Merchan said that's fine and granted it. As it turned out, as always happens, lawyers always take longer than they project to take. It's never shorter. And what ended up happening was that Trump's lawyer spoke for 2.5 to 3 hours, and then the prosecution went on for 5 hours. And of course, in the midst of all of this, there were breaks in between. And in the end, it took 10 hours to do 2 closing statements, and they ended at 8 p.m., which, I don't know, that seems a little nuts to me. That's very late to be holding jurors, and kind of more to the point, just a really long time to give to the lawyers. Every judge I've ever appeared before, the judge is actually controlling that amount of time, limiting it. Sometimes as a lawyer, as the federal prosecutor, I would, become frustrated because I felt like more time was necessary. I did a case that was probably more complicated than this one, in that there were hundreds of exhibits. It was just a much more complicated scheme. It involved many different victims. And we got 1 hour to do the closing arguments. And it forced me, and it forced the other side, to really kind of distill down to its essence the most important points. Closing arguments should not be a rehash of everything that was said in the trial. And even if you had 5 hours, and even if the judge is willing to go along with it, I would really question whether that is good advocacy. Again, I can't say whether it was a good or bad closing argument because I was not literally there. I have seen all of the blow-by-blow accounts, but I find it hard to believe that 5 hours with breaks in between and going into great detail about every point was a scintillating presentation. I just can't believe that. One of the things that you learn as a courtroom advocate, and just as a public speaker generally, is the limited amount of information, the limited number of concepts that people can take in when they are sitting there and listening. Generally speaking, people can take in 2, maybe 3 points maximum. That's all they're really going to remember. So I always used to think about that, because if that's true, I want to make sure that those 2 or 3 points that they're remembering and they're taking in are the 2 or 3 points that are the most important things, the things that I want them to come away with. And it's just the nature of the beast. Lawyers tend to do this. They never want to leave anything out. They think they have a million great points. But the reality is that if your top 2 or 3 arguments are not persuasive, if those 2 or 3 arguments don't get you to where you want to go with your audience, which is the jury, it's pretty unlikely that numbers 4 through 10 are going to pull it off. By definition, they are less persuasive. So I found it kind of interesting, that the judge would allow such lengthy closing arguments. Again, as I said, every judge I've ever been before, they're very solicitous of the jury. They're very concerned about the jury being able to take everything in. Judges often, and usually, are very skeptical about lawyers demanding more and more time. Judges understand, because they've been there themselves. Judges are former lawyers. They understand that lawyers tend to want to belabor things, tend to want to talk about things too long, longer than necessary. So it really fell to the advocates on each side to police themselves, because the judge was allowing them to go as long as they wanted. And as far as I can tell, there wasn't that much discipline exercise in terms of picking and choosing the best battles. And that's just probably not the best advocacy. We'll see. But I find it hard to believe that those 5 hours could not have been pared down, or even the 2.5 or 3 hours could not have been pared down. I believe at one point, from one report that I read, the prosecutor, he actually kind of joked with the jury as he was beginning to go through exhibits, and he says to the jury, "Oh man, is this guy really going to go through all the exhibits one by one?" And I guess there was a little bit of a laughter. So, I mean, I guess it was good that he was able to laugh at himself a little bit with that, but it would also raise for me the question of, why are you doing this? Why are you going through every exhibit one by one? So that's my take on the length. I think that was probably way too long. With respect to the prosecution's main themes, its arguments, I found it interesting that they followed their lead from the opening statements of big picturing it and making it about election interference writ large, that it's about Donald Trump in general, that it's about the 2016 election, the outcome. He actually talked about how the outcome of the 2016 election could have been different had Trump not engaged in this hush money scheme. And the argument that the prosecutor was making was that by engaging in the hush money scheme, by paying for Stormy Daniels' silence, that Trump had denied access to information that voters needed, which presumed that the voters are somehow entitled unencumbered or unfiltered information about the candidates. Now, as a matter of public policy, I think that is a very fine argument to make, but that's not what the jury is there to decide. And if I was the district attorney's office, I'd be a little worried that a closing argument like that hits such broad themes and is designed to appeal to the emotions of the jury would be deemed on appeal, if Trump is convicted, as being inflammatory and perhaps even misleading, because it's leading the jury away from the issues they're actually being asked to decide. Because the jury is not going to be asked to decide whether there was election interference. No matter how much they want to frame it that way, that is not what the indictment says. The indictment charges these false records. That's it. Those false record counts also include an allegation of an intent to commit another crime. And more specifically, with respect to the election law violation, which these false record counts are attempting to pick up and incorporate as being that second crime that Trump was intending to commit, the question there is not whether you engaged in election interference or influencing the election, but whether you did so through unlawful means. So all of the throat clearing, all of the framing, all of the big picturing of putting it in the context of the 2016 election, of Trump writ large, of the whole national election, that is leading you away from whether or not Trump intended to influence the election through unlawful means. And those unlawful means, apparently, through the prosecution's theory, is that Trump engaged in a campaign finance law violation. In other words, to give his campaign an illegal campaign contribution by paying Stormy Daniels that money. That money was intended to benefit the campaign. That is a much more discrete issue than the themes that the prosecution was sounding yesterday. And it's in keeping with the way that they have tried this case, where comparatively little evidence has been introduced about Trump's intent to commit that other crime, what that crime actually is, the elements of that crime, the nuances of campaign finance law. I mention all of this in part because one of the most common ways that a criminal defendant's conviction can be overturned is through improper closing arguments by the prosecution. So in other words, you could have a conviction that is supported by sufficient evidence introduced at trial, a conviction that is supported by correct jury instructions, in other words, a correct instruction on the law. But if the prosecutor crosses the line in closing arguments, then the conviction can be overturned. So there's a danger there. You need to be careful. You need to be very, very careful if you're the prosecutor, because you could have tried the case perfectly up to this point and you could blow it in closing arguments. Which brings me to the defense closing. And I'd just like to make a couple of points about it and how the defendant's lawyer is kind of operating under a different set of rules. Now, not technically, the rules still apply, but the consequences for breaking the rules are different. So yesterday, you saw Judge Merchan become very upset with Trump's lawyer for having brought up the potential punishment of Trump in the event of conviction. I believe he argued, ladies and gentlemen, do you want to send a man to jail over the word of Michael Cohen or based on the word of Michael Cohen? So it's perfectly fine to argue Michael Cohen's credibility, but to bring up the potential consequence of a conviction, that is improper. That is not the jury's role. The jury is not to consider the punishment. The jury's not going to decide the punishment. The jury is deciding whether the defendant is guilty or not guilty of the crimes that are in the indictment. And if there is a guilty verdict, then the judge, and only the judge, will be deciding the sentence. So it's really inflammatory, it's misleading, it's improper for the defense lawyer to get the jury thinking about punishment, because the jury may refrain from finding a defendant guilty, even if they believe the defendant is guilty, if they think that the conviction would bring with it a punishment that is disproportionate to the seriousness of the crime. That's the concern. And that's exactly why defense lawyers, like Trump's lawyer was doing yesterday, was doing it. He was trying to engage in what we call jury nullification, of the jury rendering a decision on something besides the facts and the law. Now, I just mentioned how the consequences for breaking the rules are different for different sides. Now, if the prosecution engages in misconduct during closing argument, and I'll use a clear example of that, which would be commenting on the defendant's invocation of his right to remain silent. In other words, talking about the defendant's failure to testify at the trial. That would be unconstitutional because the defendant has a right to remain silent under the Fifth Amendment to the Constitution, and commenting on it and drawing any kind of negative inference for invoking that right is improper and will almost certainly lead to the reversal of the conviction if the prosecution does it. On the other hand, if the defense lawyer engages in improper closing argument, like the one that Trump's lawyer did by talking about potential punishment, the consequence is not the same. Because if Trump's lawyer is successful and gets an acquittal based on an improper closing argument, you could call this an improper acquittal, there's no recourse for the prosecution. The reason for that is the double jeopardy clause of the Constitution, which says that you cannot be retried on charges that you've been acquitted of, even if that acquittal was obtained through improper means. So it's not a fair fight, basically. The defense lawyers sometimes engage in these dirty tricks. I must say, as when I was trying criminal cases with the Department of Justice, I hated it when the defense would do that sort of thing. Another time yesterday, when the defense did that, they accused the prosecution of knowingly relying upon perjured testimony or lying witnesses. The prosecution objected to that argument, and Judge Merchan sustained the objection because it was clearly improper. However, it's a real strategic matter for the prosecution to even object. Why? Because it draws more attention to the argument, and it implies that what the defense has said hurts you, that somehow they've kind of struck a nerve. And by objecting to it and having the judge rule on it, it draws even more attention to the thing that the jury should not be considering. Now, the defense made a big point, not surprisingly at all, of calling Michael Cohen a liar. There were some clever turns of phrase, or maybe not that clever, but there were definitely preconceived turns of phrase. Michael Cohen was described as the MVP of lying, the gloat, the greatest liar of all time. They probably had a good time with that back in the conference room, coming up with that one. It was a lot of liar, 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 lying, lying, lying. Defense lawyers love to do that. And this is an area actually where the law is actually pretty fraught. A lot of jurisdictions, I did a whole study on this one time. I published a law review article on the law of closing arguments, and specifically whether you can call a witness who has testified a liar. And a lot of jurisdictions say that if the prosecution does it, then it is reversible error. I've got to say that this is an area of the law that doesn't make that much sense to me, because you can then use synonyms for liar. You can say that somebody was making up a story, or that somebody was creating something out of whole cloth or something like that. But there's a real red line, at least in a lot of jurisdictions, with the use of the word liar. Again, this is a line that criminal defense lawyers routinely cross. Why? Because there's no consequence to it. And if you, as the prosecutor, are always objecting every time that the defense is calling your witnesses liars, again, it draws more attention to it, and you might as well just accept that that argument is going to be made. The jury is going to have to decide whether that line of attack is ultimately effective, but that seems to be the main thrust of the defense's argument. So that's it for my top line observations about closing arguments yesterday. Too long, a little bit out of order in my opinion, and the prosecution's theme was a bit too broad given what had to be proven, and the defense lawyer engaging in some typical dirty tricks. So that's it for today. You can find the Law of the Case podcast on Amazon Music. You can find it on YouTube. You can find it on Spotify and most major podcast apps. We are on Twitter. We are on Facebook. And you can email the show at lawofthecase@gmail.com. Until next time.